This is Do It for the Case Law for Tuesday, August the 4th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today's docket features 86 federal appellate opinions across 11 circuits. Our team covers a wide range of topics including criminal justice with drug trafficking and firearms cases, civil rights matters involving Section 1983 claims and prisoner litigation, constitutional challenges, business disputes, immigration appeals, and administrative agency reviews. Please subscribe to stay updated on the latest federal appellate decisions. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. 28 criminal justice cases from across the country. The disposition roll-up shows 21 affirmances, 1 dismissal, 2 split outcomes, and 4 reversals or vacators. Starting with movements in the Fourth Circuit, David Lee Graham's sentence was vacated and remanded because the written judgment expanded his supervised release search conditions beyond what was orally pronounced. In a split outcome for Keiwan Gregg, the court affirmed his supervised release revocation but dismissed his challenge to his fentanyl possession sentence due to a valid plea waiver. Over in the Eighth Circuit, Christopher Spider's conviction for meth conspiracy and witness tampering was affirmed while Lance Brunsting's convictions were vacated because he passed away during the appeal. Moving to the Seventh Circuit, 4 Gangster Disciples defendants, including Sean Clement, Demeek Maxwell, Warren Griffin, and Frank Smith, received life sentences on racketeering and murder charges. One of these appeals involved a procedural error where the district court failed to require a pretrial proffer for co-conspirator statements, but the appellate court found that error harmless given the overwhelming evidence. In the First Circuit, Christian Joel Andino Arroyo's 36-month prison term was affirmed as reasonable following multiple supervised release revocations. The 11th Circuit issued 3 affirmances. Eloquandra in
despite claiming a minor role adjustment in David Smith's motion to reduce his mandatory life sentence was rejected because he failed to show an intervening change in the law.
In the Fourth Circuit, Divon Mickens was affirmed on a felon in possession charge where his prior Virginia conviction was correctly classified as a crime of violence, and Jack Flanders was affirmed for engaging in illicit sexual conduct with a minor abroad. The Sixth Circuit affirmed 3 cases. Jared Metzger's suppression motion was denied based on good faith reliance on a warrant. Hugo Benavides received a 96-month sentence for drug conspiracy with proper application of dangerous weapon enhancements, and Kenneth Jackson Jr. was affirmed on his resented term after the First Step Act. In the Eighth Circuit, Derek Underdahl was affirmed for possessing ammunition as a felon. Darren Duncan was affirmed for distributing fentanyl, and Eagle Wind Lejeunesse was affirmed on a supervised release revocation. The Ninth Circuit saw a major shift where Amazon.com Services was denied a preliminary injunction against Perplexity AI because the court found that the AI agent did not directly access Amazon's computers under the Computer Fraud and Abuse Act. Several other Ninth Circuit cases were affirmed, including Philip Gomez, Abdul Howard, Marlon Rogers, and 2 supervised release revocations for Bradford and Gallardo. The District of Columbia Circuit reversed a summary judgment against victims of state-sponsored terrorism, holding that proceeds from British American Tobacco's criminal penalties must go to the United States Victims of State-Sponsored Terrorism Fund. Finally, the Federal Circuit affirmed a dismissal in Johnson versus the United States because the claim for military disability benefits was filed well past the 6-year statute of limitations. Back to you, David.
Thanks, James. Let's turn to Aisha covering civil rights cases.
Thanks, David. In this block, we have 16 cases from 6 circuits. The disposition roll-up shows 12 affirmances, 1 dismissal, and 3 split outcomes where the court vacated or remanded. We begin with a significant First Circuit ruling on free speech. The court affirmed a permanent injunction barring enforcement of a Puerto Rico law that criminalized disseminating false information during a state of emergency, holding the provision violated the First and 14th Amendments as an impermissible content-based restriction, failing strict scrutiny. Moving to the 10th Circuit, 1 lower priority case was affirmed without further detail on the specific issue. Over in the 11th Circuit, the court affirmed a daycare director's conviction for failing to report suspected child abuse, finding sufficient evidence that she suspected mental injury based on employee reports and video footage of mistreatment. In the 4th Circuit, we see a mix of outcomes. The court vacated and remanded a qualified immunity denial for a school official who contacted a medical provider about an FMLA certification without first offering a cure period, ruling that right was not clearly established at the time. However, the court affirmed summary judgment in 2 other Fourth Circuit cases, one involving a daycare director's Title VII and age discrimination claims dismissed for lack of reversible error, and another affirming dismissal of a civil rights complaint alleging excessive force where body camera footage contradicted the plaintiff's account of the suspect's movements. Next, the Sixth Circuit handled two matters. One appeal was dismissed for lack of jurisdiction because officers failed to concede the plaintiff's factual version required for interlocutory review of qualified immunity. The other affirmed the denial of a preliminary injunction for an employee seeking to stop termination, ruling that loss of income is reparable through monetary damages and thus irreparable harm was not shown. Moving to the Seventh Circuit, the court affirmed summary judgment for defendants in a hostile work environment claim, finding sporadic vulgar banter was not severe enough to alter employment conditions under Title VII and the Rehabilitation Act. The Eighth Circuit resolved one lower priority case with an affirmance. Finally, the Ninth Circuit issued 8 affirmances. These include rulings on excessive force where in-car footage contradicted the plaintiff's account, dismissal of claims against a private hospital for failure to state a claim regarding state action, and affirmance of summary judgment against a RE-LID license denial due to lack of a private right of action. The court also affirmed judgments in cases involving prisoner access to courts claims where no actual injury was shown, dismissal of an ADA challenge for abandonment of arguments on appeal, and affirmation of summary judgment for county officials in a sewage overflow case where supervisory liability was not proven. Back to you, David.
Thanks, Aisha. Now let's turn to Michael for constitutional and habeas coverage.
Thanks, David. 13 cases in this block. 3 were vacated and remanded, 2 were denied, and 8 were affirmed or dismissed. Moving to the 11th Circuit, the court vacated a district court's universal injunction against Florida's Protection of Children Act, ruling such broad orders lack historical authority and that the statute likely survives rational basis review. Over in the 4th Circuit, the court vacated summary judgment for prison officials in a First Amendment retaliation case, finding the plaintiff properly exhausted administrative remedies, and remanded 8th Amendment conditions claims to determine if grievance procedures were genuinely available. In the 9th Circuit, the court vacated the dismissal of IE Lu's habeas petition because she raised non-frivolous claims that require a full response from the government. Back to you, David.
Thanks, Michael. Now Maria joins us with the business and civil rulings.
Thanks, David. 25 cases for today's business and civil coverage across 6 circuits. The disposition roll-up includes 19 affirmances, 2 dismissals, 1 denial, 4 reversals or vacators with remands, and 1 split outcome. Leading with the significant movements, the 9th Circuit reversed a district court order blocking the Federal Trade Commission from collecting on a money judgment against Benjamin Hoskins and Leanne Rogers for their telemarketing scam, holding that the Federal Debt Collection Procedure Act preempts Nevada's 6-year statute of limitations because no time limit exists for collecting debts owed to the United States. The panel also vacated a permanent injunction in favor of Jack Daniels in a trademark dilution by tarnishment case against VIP products, ruling that the plaintiff failed to prove fame for Old Number 7 and that the Bad Spaniels toy was not facially tarnishing. In another labor law development, the 9th Circuit vacated an order denying back pay to Unite Here International Union against Sky Chefs, holding that Section 6 of the Railway Labor Act mandates maintaining the status quo as an absolute command rather than a discretionary equitable remedy. The court also remanded Leonard Mitchell's negligence claim against Air India after finding the district court abused its discretion by implicitly denying jurisdictional discovery into the airline's relationship with United Airlines.
Moving to the 11th Circuit, the court reversed a false advertising verdict and vacated damages in Deltona Transformer versus Noco Company regarding battery tender trademarks, remanding for a new trial on damages while affirming infringement findings based on Amazon ad text. The circuit also granted Jeremias Pascual Andres' petition to reopen removal proceedings, holding that the Board of Immigration Appeals abused its discretion by requiring a state bar complaint when the Executive Office for Immigration Review qualifies as an appropriate disciplinary authority under matter of Lozada. Over in the 4th Circuit, the court vacated the board's denial of cancellation of removal for Kadiatu Babila Keita because the immigration judge failed to hold a promised evidentiary hearing regarding exceptional hardship to her United States citizen children before ruling on third country removal. The 7th Circuit affirmed summary judgment for Insurance Company of the West in a dispute with High Performance Alloys, holding that the Indiana Workers' Compensation Act is the exclusive remedy for workplace injuries even where gross negligence is alleged. In the 3rd Circuit, the court affirmed the dismissal of Paul Lissendy's False Claims Act retaliation claim against Olympus, determining that his concerns about FDA violations did not connect to a reasonable belief of fraud against the government. The 8th Circuit upheld a contract dispute judgment in favor of Robert Cupper and Bismarck Motor Company against FAND Chev regarding car dealership sales, finding that the defense of failure of consideration failed because the dealerships met earnings targets. Routine affirmances include Valesa Drawn's untimely appeal from a Merit System Protection Board decision in the 4th Circuit. The 4th Circuit also affirmed summary judgment for the Central Intelligence Agency in a Freedom of Information Act case regarding prisoners of war, finding no improper withholding while searches continued. In the 9th Circuit, routine outcomes included affirming denial of pro bono counsel and summary judgment against Elena Criley in a medical injury case, dismissing Linda First Main's legal malpractice claim as time-barred under Arizona law, and dismissing Fields v. AAA Life Insurance for lack of standing due to fraudulent joinder. The court also affirmed the bankruptcy appellate panel's denial of dismissal motions in Ingrina Innovative Securities and Exchange Commission's denial of relief from judgment against Charles Everett and denied a petition for review regarding Oscar Hernandez's asylum claim. Additionally, the Ninth Circuit remanded Rodriguez-Garcia versus Blanche to consider a defective notice to appear after the petitioner forfeited other claims. In the Federal Circuit, the court affirmed non-infringement in Skylex Pharmaceuticals versus Aveva Drug Delivery Systems but vacated a preliminary injunction against Import Global and Socket Solutions, ruling that the district court erred in construing the term backplate. Back to you, David.
Thanks, Maria. Let's turn to Raj covering immigration and government law.
Thanks, David. 4 cases on the docket today across 3 circuits, 1 split outcome, 2 denials, and 1 dismissal. The most significant movement comes from the 7th Circuit in Halil Demir versus Markwayne Mullen. The court reversed part of the lower court's dismissal, holding that federal statutes channeling challenges to Transportation Security Administration orders direct to courts of appeals do not apply to FBI terrorist watch list claims, since the TSA lacks authority over those lists. Consequently, the court remanded the Substantive Due Process and Administrative Procedure Act claims regarding watchlist status to the district court for consideration on the merits while affirming the dismissal of the Traveler Redress Inquiry Program challenge. Moving to the 11th Circuit, 2 immigration petitions faced rejection. The court denied a petition by Fernando Jose Obando Brizuela and family members seeking asylum, withholding of removal and relief under the United Nations Convention Against Torture, ruling that intermittent police presence and vague threats amounted to harassment rather than persecution. In a separate jurisdictional dismissal, the court lacked authority to review the denial of cancellation of removal for Joseph Augustus Arthur Coleman because the immigration judge made an independent discretionary determination at Step 2 of the inquiry. Finally, over in the 4th Circuit, the court denied a petition by Bluff Spur Coal Corporation challenging black lung benefits awarded to Frederick Bateman, finding that the administrative law judge's factual findings regarding total disability and smoking history were supported by substantial evidence. Back to you, David.
That brings us to the end of today's broadcast for Tuesday, August 4th, 2026. We want to thank our reporters for their hard work covering the day's federal appellate decisions. James Taylor handled 28 cases on criminal justice beats. Aisha Johnson covered 16 civil rights matters. Michael Reeves brought us 13 stories on Supreme Court and constitutional law. Maria Santos reported on 25 business, labor, and civil cases. And Raj Patel wrapped up 4 immigration and government appeals. The most significant outcomes from today's docket included several reversals, vacated decisions, and remands that will shape future litigation. Meanwhile, a number of cases were dismissed on procedural grounds. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Please subscribe to the show and follow us for daily updates on federal appellate law.